I got a bankruptcy question. It comes out and says, how difficult will it be to file Chapter 7 under the new bankruptcy laws? And it's from Jane. Jane, it's not difficult at all if you're working with an experienced attorney, because the attorney should have a protocol of everything you need to do to get your case filed. Likewise, after you file, then you've got more things or more steps you need to take to get yourself a discharge and go forward with your life. So it's not that difficult if you know the proper steps and in what order to take them. If anybody who's filed bankruptcies before understands the process. However, each case is different. In other words, if you come to me and say, yeah, I'm a small business owner, I'm going to ask you, okay, is it a corporation, is it an LLC, or is it a sole proprietorship? If that's, let's say, your sole proprietorship, well, then I'm going to need X, Y, and Z on top of your basic living expenses, da-da-da-da-da. Electric bills, water bills, cable bills, everything, all that, everything to that effect. So it's not difficult if you know what you're doing. There are a lot of paperwork requirements. Don't get me wrong. I'm not going to sell it short. Right now, we're giving more paper to the bankruptcy court than we've ever given before, even when this law was implemented. It seems the paperwork has gone up and up and up and up and up. And I understand that. The bankruptcy trustees have to cross their T's and dot their I's. I have no problem with that. I really don't. What I'm always concerned about is whether my clients can produce the documentation that I'm asking for. I mean, one of the biggest complaints I get is, Carmen, why all this paperwork? And I say, you're absolutely right. Call your congressman. Call your senator. The yo-yos up in Washington are the ones who came up with this law, and now it's getting to the point of where, it's just like, in some point in time, I tell people, it's insane how much paperwork we have to produce to justify what you're saying. On one hand, you're saying this is true and correct under penalties of perjury. On the other hand, they're saying, well, that's not good enough. Now you got to produce paper to show that your electric bill is $250 a month, when you're saying over here, my electric bill is approximately $250 a month. Sometimes it just gets bizarre. I personally not worried about it because I ask my clients, what's your average monthly electric bill? And they tell me. I trust them. I said, just give me documentation to support it, because I know I may have to produce that one day. Same thing with car insurance. We talked to somebody the other day, their car insurance was sky high. I asked them to show me the premium statements. They showed them to me, no problem. Now, if it is a bankruptcy trustee going to ask about that, you better believe it. So I better have that paperwork ready to justify what my client says is true and correct. Some people have special diets. The bankruptcy court usually allows $200 to $250 a person in a household for food on a monthly basis. I think that's silly, $250 a month for food. I think that's a joke in today's market. I mean, goodness gracious, what's a gallon of milk cost? So you can't give your kids milk anymore? It gets to the point of just being silly. What about somebody with special dietary needs? All of a sudden now I got to produce Publix receipts for what they buy for food, because the bankruptcy trustee has to justify this to themselves and to their bosses. Again, I have to look at it and say, you know what? My client, the ultimate relief for them is the discharge. So we're going to do what we have to do to get them that discharge. If that means producing some paperwork, if that means, showing some receipts for medical expenses or for prescriptions, I'm not going to tell them what their prescriptions are, but I am going to show them the receipts from the Target pharmacy or from the Walmart pharmacy, wherever you get your prescriptions made, showing them what my clients pay for prescriptions that are necessary for the medical attention. So yes, is it difficult? It could be if you tried it on your own, or if it could be if you used an inexperienced bankruptcy attorney. If you work with an experienced bankruptcy attorney, they have the protocols they need. You got to remember, if your bankruptcy attorney is asking for the information, it's not because we like paper. It's because we have to produce this stuff to the trustee, or we're going to get a motion to dismiss your case from the U.S. trustee saying, hey, produce these documents. Do this, do this. Show me why your client is entitled to this relief. Demonstrate to me that your medical bills are X amount of dollars per month. And we have to. And as doing this on day in and day out, I can tell you what we're going to need and what we're not going to need. What's relevant, what's not relevant. Okay? So yes, definitely before you decide, interview several attorneys, see who you like, who you're willing to work with, who you're willing to trust with your case. And if you don't like an attorney, by all means, you have the right to choose another one. Picking an attorney is probably one of the biggest things that people talk to me about. How do I pick a great attorney? Well, you have to look and have to feel it with that attorney. I'm sure there's people who've interviewed me who said, no, this guy, he's just not the one for me, and they've gone to another attorney. I'm okay with that because the attorney-client relationship is based upon mutual trust and mutual respect. And if you don't feel it at the time of the case, at the time you're hiring that attorney, then go see someone else. You know, I've had people who came to see me, went and saw somebody else, and came back and hired me and said, nope, I want you. I'm okay with that. Again, I have no problem with you going to see multiple attorneys. Just don't feel pressured by the attorney to sign with that attorney. That, to me, creates a bad relationship. It should be no pressure. It should be no stress. It should be easy. It should be, I want to work with this person. That's the way the relationship should be, because I'm going to be asking you to do a lot to get this case ready. So it's a lot going on there.